So we meet in the last session just after 15 minutes. Thank you. Session Shri K K Ramani, may I request Praveen Shah to escort the sir to the dais.
वो 1 करोड़ का डिमांड आया, 30,000 रुपये का।
सर जी थोड़ा साइड।
May I request Pranav Kapadia to do the honors of escorting Shri K K Ramani to dais. May I request Shri Girish Rathi to escort the speaker CA Ashwin Shah to the dais. I request the other authorities to take their seats on the dais. Introducing our today's session chairman, Shri K K Ramani sir. He is the author and co-author of many books, RERA and Capital Gains 2018 edition, Wills, Nominations and Succession, Real Estate, Regulation and Development Act 2016 RERA, to name the few. He was the president of Chamber of Tax Consultants, Rotary Club of Bombay Seacoast, and chairman of West Zone AIFTP. He was also bestowed upon with the prestigious Mother Teresa International Award 2015 for his contribution in the field of social work. With a great round of applause, please help me welcome Shri K K Ramani. Our speaker for today's session, CA Ashwin Shah. He is a member of ICAI from 1987, practices in the area of advisory and litigation with specialization in real estate industry for direct and indirect taxation. He is the director of Netra Realty Solution Private Limited Company. He has written articles of professional interest in various magazines, has delivered more than 25 presentations on RERA at various professional and business forums. We are very fortunate to have CA Ashwin Shah as a speaker. I request our chairman sir for his introductory remarks.
Mr. Vijay K. Ramani, Mr. Ashwin Shah, Mr. Praveen Shah, Mr. Pranav Kapadia, Girish Rathi, and friends. RERA has completed 16 months of its operation. During this period, most of the states have already set up their regulatory authorities and appellate tribunals. While I am glad to say that authorities like Maharashtra and Madhya Pradesh are doing wonderful work, but I am also sorry to say that some of the states have not set up the authorities in their own states. West Bengal has not taken any step to set up authority or rules frame the rules. This is the way that the Center Act is being treated by some of the states. At this conference, I am told there are delegates from all parts of the country. This unique gathering from representing all the states probably is the most appropriate place to take stock of the situation. If you ask any consumer, any purchaser of the real estate, he says RERA has done wonderful work. I got so much amount by way of penalty, compensation and interest. All consumers throughout the state are happy after the commencement of the act. But if you ask any builder, he says, don't ask me, this government has done to me. Our business has come to a halt. First, there was demonetization, then GST, then RERA. All the three have broken our backbone. So, what I think it's the right time to consider what were the things earlier, what is now and what's going to happen. रेरा से पहले बिल्डर कहाँ थे, कहाँ आ गए और कहाँ पहुंचेंगे अभी, आओ विचारें आज मिलकर ये समस्याएं हैं सर. This conference is a timely setup, very well organized by All India Federation of Tax Practitioners along with other associations. As I said earlier, although RERA is a central act, but rule-making authority is given to the states and other appropriate government, the union territories. It seems, while framing the rules, many states have diluted their rules. It's a breach of legal principle that no subordinate legislation can override the substantive provisions of law. But these rules are, of course, overriding some of the provisions of substantive main laws. Let me give some few examples. Withdrawal from specified bank accounts, artificial meaning given to the ongoing project. There is a provision of working out cost of the land, but that provision has been substituted by cost, taking the land value, substituting cost by the land value. As we have income tax, we take the value of 2001, then index it. Same provision has been applied for taking the land cost. How can the land value be substituted in place of land cost? But that has been done by the rules. Then there are provision in the RERA section 11(4)(e) read with section 17 about conveyance. But the rules we find they are totally different. So that way there are many rules which are really not in conformity with the main provisions of the law, because these are beneficial that nobody is going to challenge. But what will happen if these rules are challenged someday? It's anybody's guess. At present, if you see that whatever cases are being reported, all these cases are regarding ongoing projects. Because the new cases will take time, 2-3 years to come up, those disputes, etc. In the absence of it, but what is ongoing project? It has not been defined in the Act, nor by any other states, most of the states. So every authority is taking its own view to decide what is ongoing project. Now, it's possible that the meaning of ongoing project given in Maharashtra will be different from Gujarat or in Madhya Pradesh. But let me tell you, there is what is happening in the state. Even the members of the state are not able to come to the same view. One member says this is the one view, and another member within the same state is giving different meaning to the term ongoing project. This creates, each case is generally being decided by a single member. So far, it's not the case where the 2 or 3 members sit together to decide any controversial issues. But each person is independent. With the result, their views on the same subject are coming divergently. This is, of course, I think it will take time to come to the definite conclusion, because same act is being interpreted in different states in different manner. Now, what are unregistered projects has not been defined under the Act. So this question may also bring some complication. Most of the projects which complaints are filed, as I said, these are regarding ongoing projects, and all these agreements were executed prior to 1517, and all these agreements are not as per the RERA but MOFA, Maharashtra Ownership Flats Act. Now, whether these will be decided as per the terms of MOFA or RERA is not clear, should not be there. When the agreement was executed, MOFA regime, as per the MOFA, now MOFA provided the same rate of interest at 9%. Now RERA provides rate of interest, maximum lending rate of banks, State Bank of India plus 2%, which comes to 10.05 today. Which rate would be applicable? Because the agreement was executed when it was in conformity with the MOFA. So, and the section 8B, if you read, clearly said delay will attract interest at 9%. What should be the rate applicable? 9% or current rate? So these are all so many things which are happening, which are still not clear. We are having RERA and MOFA, both the regions are combined. I have expressed my views on the basis of my little knowledge of RERA in Maharashtra. Learned professionals from other states are also here, and they will express their own views about their experience in their own states, so that we can learn something about the working of RERA for the whole country. And I am sure all of us will be benefited by today's deliberation. I have seen the PowerPoints prepared by learned chartered accountant Ashwin Shah. Here, these are very useful points. He will discuss those points now. And I am sure after hearing him, you will be satisfied and you will go with a little better knowledge. Thank you very much.
Thank you so much, sir. C. Ashwin Shah, the floor is yours.
Chairman of the session, Senior Counsel Advocate Ramani ji, dignitaries on the dais, Chairman of the conference K K Ramani, seniors, ladies and gentlemen. Suddenly the Duckworth-Lewis formula has been implemented, and I have been told okay, now I have to score 200 runs in 10 overs. So I will be going little fast. So before we go to the integrity of RERA, let us first examine why we need a RERA. Like in a country like India, where we have 28 states and so many union territories, there was no state law. In almost very few states we have the state law, like in Maharashtra we have the MOFA, in Gujarat we have BOFA, but in other states, even the giant state like Uttar Pradesh does not have any local law to regulate the construction industry under construction flats. So prior to RERA, there were no such local laws. So developers took the advantage of all this situation. Again, the regulating authority was court. So if person is aggrieved, he has to go to the court, and as discussed by in the first inauguration session, the courts take its own time. It takes 10 to 15 years to give the justice. So there were anti-consumer practices followed at almost many remote places, and the epicenter of RERA is Noida, where the builder might take some title in land A, the project is advertised on land B, and the sales office is situated on land C, and finally delivery may or may not come, but if it comes on land D. So this is the situation. So the epicenter was Noida, and then the central government thought, okay, let's have some central law. So they introduced RERA bill in 2013 in Parliament. But before that, there was one interesting incident in the state of Maharashtra, because Maharashtra was always pioneer, because here the housing development was much ahead than any other state. So Maharashtra introduced one bill called MHRD, that is Maharashtra Housing and Housing Regulation Development Bill 2012. That was introduced, that was pending for approval, but then 2013 central law took all the provisions of MHRD. In MHRD, the Maharashtra government intended to have one regulator. So the task of regulator is to regulate the specific industry. So the dispute resolution is very fast. So then central bill taken all the provision of MHRD and they introduced in the Parliament in 2013. Then the task was given to the Rajya Sabha for evaluation. So under the chairmanship of Sarad Yadav, the standing committee did a very good job. They called for the stakeholders relevant questions and all these things. On 3 points, they did a major change. Like initially, the RERA bill was to target only plot above 1000 square meter and above 12 apartments. So there they reduced to 508 apartments. So they wanted to have all the project, almost all the project under RERA. And the second change was initially the RERA bill was targeting only residential project, not commercial, not industrial. But with the Rajya Sabha interference, all the projects are now covered, whether it's a residential, commercial or industrial. And third most important suggestion given by Rajya Sabha was never implemented. That was, they said that there should be regulation on approval authority also, because that is the main cause of concern for any real estate industry. So there are no single window approvals and all these things. But that suggestion was never implemented and it was sidelined. So again there was absence of professionalism and standardization. Like each builder used to have its own draft agreement. Many times they don't even write the possession date. And there was, so now with RERA you have all the standardization. Now builder will have to follow a particular format of the agreement. Even under MOFA it was there. But builder were never afraid of the MOFA because they know that if any customer want to go, he will have to go to the court of law and he will have more time, 10 to 15 years. So there was no fear of law in the mind of developer. So now at least we have professionalism and standardization. Then one-sided contract. If we see any MOFA agreement, generally you will find one-sided contract like interest. If builder has to pay interest, it is 9% per annum. If the customer delays the payment, then it is 24%, 21% like that. Then again on possession also, builder writes that he will have this disclaimer. So there were all the one-sided contract. Fly-by-night developer, like just pay 5% balance on possession, but that balance never comes. Right? This was the marketing gimmicks by the developer. Just to give you an example, one tax practitioner dies and near the door of Swarg and Nark, an officer was sitting. He was looking at the ledger account of that tax practitioner. So there he was surprised to see that paps are equal to punya. So he was surprised. He said, how it is? Sir, ये तो मेरा रोज का काम है. मैं घर पे तभी जाता हूँ जब tally हो जाए सब. Everything gets tallied. This is my daily task. And officer said, okay, but now whether I should send you to Swarg or not? So then tax practitioner said, okay, give me choice. So okay, you tell me where you want to go. Then he said, okay, I want to have physical verification. So then that officer called one sales girl and told her कि इनको दोनों लोकेशन दिखा तो पहले नर्क में जाते हैं. So in नर्क वो देखता है तो एकदम खुश हो जाता है. All mall, multiplex, bar and restaurant, dancing girl, casinos. नर्क इतना अच्छा है तो स्वर्ग कितना अच्छा होगा. So then he goes to स्वर्ग. स्वर्ग में देखता है तो बहुत बड़े बड़े बगीचे थे. एक बगीचे में गांधी जी लोगों को उपदेश दे रहे थे, झूठ मत बोलो, हिंसा मत करो, अच्छी तरीके से रहो. And then in second garden, Jawaharlal Nehru was playing with some children. And at third point he said कि Sardar Vallabhbhai Patel was looking at earth, particularly Jammu and Kashmir, कि what is the position. So then he decided, Swarg is a boring place, so let me go to Nark. So he put up a tick on Nark, and then he was taken. Then that sales girl went away, and then one Kala Admi, he took him to the Nark. As soon as he entered the Nark, he was beaten like anything. He was fried in the oil and all that, whatever we understand of the Nark. Then in the evening, he came to the officer and said, hey, what is this? What I have been shown and what you are giving me? That is our marketing skill. So that is why builder also do all these marketing skills. Again, builder, the main reason for RERA to come in is builder used to create a land bank with the use of project 1 money for land bank for project 2, 3, 4, 5 and so on. So project 1 is always delayed. He just go on taking the land bank. मेरे पास 25 साल का काम होना चाहिए. भले पैसा 25 रुपया भी नहीं है, भाई 25 साल का काम होना चाहिए. Yeah, Supreme Court also observed in many cases like Pepsi Cola and other society, the buyers are always bechara. He does not know because he is not given the information. Now with RERA there is a transparency. Before anybody books any flat, now you can go to RERA website, check all the documents, take the consultancy and then decide. So now he has a better place. Delay in judicial system is already discussed in the inaugural session. Yeah, as learned chairman said, okay, all the problems are with ongoing project. So there was a lot of hue and cry between the developer community, amongst the developer community, about the ongoing project. They were happy that RERA is coming. You apply RERA to the new project, those projects which are starting after 1st May 2017. But don't apply to the ongoing project. So there was challenge, nearly 9 writ petitions were filed all across the India against the Union of India, challenging the constitutional validity of RERA on the ongoing project. So then Supreme Court decided to merge all these writ petition, and then the task was given to the High Court Mumbai to decide the matter. So then two judge bank judgment, Judge Naresh Patil and Ketkar, yeah. So they were given this task. Even there were some amicus curiae was also there. It's a 330-page landmark judgment. Though the pages are 330, but internally also, if you go, there are n number of Supreme Court and High Court judgments. So effectively, if we take count, the judgment is more than 5,000 pages. Right? So here, the main challenge was Section 3, which says that ongoing projects should also get registered with the RERA. So that was constitutionally challenged. But then Additional Solicitor General argued before the court on behalf of government, first of all, whether these RERA provisions are harsh or no. So he said that what we are telling the developer is to deposit only 70% of the amount collected, which is very obvious for any project. So these provisions are not harsh. So then after a long debate, High Court decided that yes, constitutionally the provisions are valid and the constitutional challenge was removed. Then again Section 4(2) LD and RERA rule, as Sir said, there are dilution by various states. Now actually the developer were required to deposit 70% of the money for the ongoing project. So suppose for example developer has collected 100 crores and he has utilized only 40 crores on the date of registration. So then 30 crores he has to give account of that 30 crores. So either that should be the bank balance, or if there is no such bank balance, then naturally it's a diversion. So at least he should give account of 70 crores. But now RERA rule says that amount to be realized in future, 70% of amount to be realized in future should be deposited. So currently there is no such system to check if there is a diversion. Now all chartered accountants are required to give annual audit report on 30th September with RERA. So there we have to quantify the diversion of fund. As I explained, out of 100 crore I was supposed to incur 70 crore, but I have incurred only 40 crore. So 30 crore should be my bank balance. If it is so, then there is no diversion. But if my bank balance is only 10 crore, then 20 crores are diversion. So that we have to quantify and report. But again, after quantifying that, what is the use of that quantification? Because there is no provision under rule to call that money back by the authority. They will require the developer to deposit that 20 crore. There is no such provision. So there is a dilution. Now Section 6 provides for extension of project. That was also challenged before the High Court. Okay, why only 1 year? Because it may happen that there are some force majeure conditions. So why only 1 year? It has to be decided on merit, and then High Court said yes, it can be decided on merit of each case, but at a general 1 year extension will be allowed to all the projects. So then further extension will all depend on the merit of the case. Then developers argued under Section 7 and 8 revocation. So what will happen to our money which we have invested? So there is a provision under revocation. When the project is revoked, the authority will decide who will now take over the project, whether association of allotting or some other developer. So in that scenario, the current developer who has already invested some money, what will happen to his investment? Then court says that it is just authority will be just a facilitator. Your amount will be safe, means you will get that amount subject to your viability of the project again, because whenever there are revocation will happen only when the project is unviable. Otherwise, no developer will allow the revocation of the project. So when the situation comes of unviability, then what will happen to the developer fund which he has invested? What will happen to the other financial institutions? So again, that now this situation is not yet, not a single case has been reported for revocation. There are in various complaints, many people have claimed that this project should be revoked, but till now no authority has given any judgment on revocation. But certainly this would be a challenging task. No builder will like his project to be revoked if it is a profitable. If it is non-profitable, then no builder will take also that project. So that in that scenario, there is no clarity. Now section 18, as explained by chairman, as regards the interest liability, whether MOFA interest will apply or RERA interest will apply. So now for ongoing project, all the agreements are done in MOFA. Now defaults are continuing. The cause of action is there. So whether MOFA interest will apply or RERA interest apply. In some of the judgment, they have held that till 30th April 2017, MOFA interest should be applied. Thereafter, RERA interest should be applied. But then the question was that, is it a retrospective or retroactive? And High Court held that legislation has power to enact the law retrospectively or retroactively, provided it is in the larger public interest. So RERA is a welfare legislation. It is in the larger public interest. So RERA can have jurisdiction over the MOFA agreement, because ultimately the remedy is same, except one remedy which I will discuss. Then penalty provisions are prospective. You can't penalize a builder for his default of the earlier. For example, he has given some promise of 2016 as a possession date, but till today the delivery is not done. Now he has revised his timeline while registering the project, say 2020. So till 2020 he will not be penalized. Yes, after 2020 the penalty provision will be applicable. So penalty provisions are prospective, but section 18 is a retrospective. Then what is larger public interest? If in the shade of larger public interest, all the law start doing retrospective and retroactive amendment, then every law, every revenue law is doing the work of larger public interest. Like Income Tax Act, they say we reduce the inequalities of income. Same is the GST law. So what is larger public interest is also not defined. So ultimately all these writ petitions were disposed of, and now it is settled that ongoing projects are also subject to registration, and there is no constitutional challenge. These are the valid law.
Name of the case? There are different
Nilkamal Realtors.
Huh?
Nilkamal Realtors.
Sorry?
Petition 2737.
Now functioning of the RERA. See, RERA applies to whole of India except Jammu and Kashmir. Again, there is a facility of web-based online system. Almost many states have already operationalized the web-based system, but there are some states where again the hard copies are to be given. But now the developer says that this is a threat, RERA is a threat to us. But this web-based online system will be an opportunity for a developer to demonstrate his project. Because even if any developer, say, advertise in the Times of India by spending lakhs of rupees, but buyer, now it is very sure, the buyer will never book a flat without looking at the RERA website. So when he finalizes his decision of booking the flat, he will go to the RERA website, he will check all the details, what are the litigations, what is the past experience and all these things, what are the apartment size, what are the sold unsold ratio, progress of the work, etc. So this would be an opportunity. So developer will have to update their project on regular basis. Otherwise, on site there is 75% work done, but on site it is only 25%. So no one will book the flat. So now it is very much necessary for any developer to update the project. Then there is a regulatory authority. So the act is a central act given by central government, because the item of real estate comes under concurrent list. So both have the concurrent jurisdiction. So there is a central act and the states are told to notify the rules within 6 months from 1st May 2016. So states are given power to formulate the rules. They are given power to appoint the regulatory authority. And why this regulatory authority is required? So let's understand this regulatory task is to particularly have the focus on the complaints and grievances of the customer. So this will help in the fast track dispute resolution. As of now in Maharashtra, nearly 4,000 complaints are filed, of which they have already disposed of 2,400 complaints. So this is in the span of say 14 months. The average period of disposal is within 60-70 days. So just take a situation pre-RERA, a person who wants to file a complaint before builder, he has to go to the civil court, he has to pay the fees, again advocate fees, but here he has to just pay 5,000 rupees and he can himself go and represent the case, and majority judgment are in favor of customer. There is only one judgment, one complaint which was filed by the developer against the customer. That was interesting. That customer was deliberately not paying the installment. So then the RERA authority directed him, okay, you register the agreement and pay the installment. So that is the only one case. Then authority can function through its order and regulation, which Maharashtra has given a perfect example of how RERA can be implemented across the India. Then there will be a real estate appellate tribunal. Right now in Maharashtra, there is no such separate tribunal. They are in the process of formation. But currently the task of tribunal is given to MRT, Maharashtra Revenue Tribunal. So they are taking the charge of RERA tribunal. Then there will be one central advisory council at central level, where after 2 or 3 years, when various grievances and suggestions come all across India, they will decide to revise their policy and so on. Now what happened? Modi ji says ke forget tera mera chodo or RERA ko apna. Like have a common law across the India. That's what Modi ji wanted to say, but Didi said from West Bengal. He says no, I don't want a RERA, I want HERA. So there, what they have done is they have not notified the rules of RERA in their state. Instead of that, they have come out with a separate act, state act, named West Bengal Housing Industry Regulation Act in just 2018, January or February 2018. So that separate act is nothing but copy paste of the central act. It is same to same copy, except some 2-3 items. Now they are allowing open parking also to be sold under HERA. So now the West Bengal builders are told to register their project under HERA. Now there is a constitutional challenge, sir. RERA is in force. So RERA applies to West Bengal also. Only thing is registration can be kept in abeyance for the reason that authority is not there, state rules are not there. But RERA being a central law applies to West Bengal also. And there is one more law, HERA, which is a state law. So this is certainly a constitutional challenge, and my poser to you, sir, whether this can be challenged constitutionally, because West Bengal government has never challenged the RERA before Supreme Court. Without challenging the RERA in the Supreme Court, they have introduced HERA, that is housing under the shade of industry, because state has the power to regulate industry. So they say that real estate is an industry. So under the shade of industry, they are trying to introduce, they have already introduced HERA, and that registrations are going on. But certainly there will be a challenge. Already Central, I think National Consumer Forum has written to the Central Advisory Council to repeal the RERA. Like, see what has happened after introduction of RERA, the MHRD, which was partly notified, was repealed. Section 92 repealed the MHRD. So there is no similar act. Now again there is one more act, RERA. So there is a chance that this act will also get repealed by Central Advisory Council. Now if we look at the preamble of the RERA, it's a welfare legislation. Its main interest is to protect the fund of the customer. Whatever money you collect from the customer, that should be properly utilized. That is the main motto of the RERA. Then it also aims to give the fast track resolution, which in Maharashtra they have proved it. Yes. See what happens? Delay in justice is more dangerous than denial of justice. Suppose I am given a wrong judgment at lower level. If these things are fast, I can certainly go to the upper level and get relief. But if there is a delay of 10-15 years, like in Baroda, one of the Baroda case, there was a one person who was at his age of 25-30 years, he has given his shop on live-in license to one person. And then there was some documentation deficiency. So that person was not vacating the shop. So he got back his shop after the lapse of 40 years, when he was 70. During that process, that person was running the shop, already made 6 more shops out of the profit of that business. So this is the situation of the judicial system. Then it aims to balance the rights of developer as well as customer. It does not aim to kill the real estate industry. When we interact with the authority, they also try to, whenever the complaint goes, in the very first hearing they say, go for amicable settlement. They give the chance of 15 days, 20 days, convince both the parties, go for amicable settlement, because they know if everybody comes for refund, then the project will not get. So suppose 10% come for refund of say 10 crore rupees, then the project requires say 6 crore rupees for completion, will not get completed. So again 50% will be affected. So they are trying to balance it out. Then it provides the transparent system. Now with the website, one can very well go to the builder with all the knowledge. Previously what used to happen, whenever we go to the builder site, they used to say, "Hamara sab flat big chuka hai." They used to show us some odd flat, top floor and some odd flat. So now we can go and say, "Boss, hamara sab 20% hi bika hai." Side pe humne dekhe, we have seen that. So now they cannot do all these malpractices. Now standardization. Now each builder will be on the same footing, whether it is top line, middle line or bottom line. Each will have to follow the same system of disclosure. So now there is a comparator. Now what are the key changes? Now for the first time in India, the concept has came, you can't do any marketing without registering your product, without registering your project. So section 3 start with a negation. No promoter shall advertise book, blah blah blah, without getting project being registered. So now all the unauthorized construction and all that would be unlawful as per RERA. Again, every state there is a planning authority which declared the planning area. So RERA applies only to the planning area and not to non-planned area. Like in Gujarat, there may be some area which are non-planned area. So that are given by the local planning authority. Like in Maharashtra, MRTP is the planning authority which has declared that entire Maharashtra is planning area. So in Maharashtra, whatever development takes place, everything has to be registered. Right? So now you can't do any marketing without registering your project. So section 3 applies to the new project. Then they have given one proviso saying that ongoing project on the commencement of this act shall be registered within 90 days. So what is meant by ongoing project is not defined. So they say ongoing project means who has not received the completion certificate from the authority. You might have applied it. Architect might have given a certificate that building is ready for use. But until and unless the completion certificate comes, then that is not allowed. So if you have the completion certificate, then that project are exempted from registration. But it does not mean that project are exempted from the operation of RERA. That is what is my view. So though they are exempted from registration, but they cannot be exempted from operation. So there are some other liability of a developer like structural defect, conveyance, and so on, common amenities and all this. So they cannot be exempted from operation. Yeah, certainly they are exempted from registration.
If there is no registration, then how it operate?
Now there is one judgment by Mumbai High Court which says that actually Act provides that all the project complaint can be filed under section 31 against any project. It does not say registered project. So there is one special window on RERA website. So that by paying 5,000 rupees, you can say I want the opportunity of hearing. So then you have to give the details of the promoter and all this thing. Then they will call that promoter. They will get the thing registered if it is requiring registration, and then your matter can be taken. Now they have given some exemption from registration. If first exemption is if your completion certificate is received prior to 30th April 2017. Second exemption is plot area up to 500 square meter and apartment not in excess of, means plot area not in excess of 500 square meter and apartment not in excess of 8. Now there is one question, all of you might have got that questions. There is one question where in that question, suppose the plot area is 500, say plot area is say 400 and apartment are say 9 for example. Now whether registration is required or not? Yes, any views? So majority say yes, it is required, but unfortunately it is not so. See, section 3 gives the exemption. In that exemption, there are some conditions. Now these conditions are or condition. 500 square meter or at 8 apartment. So if I satisfy any of these conditions, then I am out of the.
No, but kindly refer, FAQ gives a different answer.
FAQ are not the law, sir. FAQ are not the law. Section will prevail over the FAQ. There are many such instances where they have themselves retreated from the FAQ. So FAQ says so, okay, yes, if the plot area is 400 and apartment is 9, you have to register. But if you read section 3, in negation it says, okay, if I satisfy any of the conditions, like
they are wrongly interpreting.
No, not. It is wrongly drafted, sir. Maybe the intention may be other way, but it is wrongly drafted. But if we go by interpretation, then yes, you don't require the registration. Then no registration without approval of plan. So now you can't register your project unless you have commencement certificate. Previously, they were allowing in the initial stage with IOD also. In Mumbai, Maharashtra, there is a concept of IOD and then commencement certificate. So now they say, no, unless you have commencement certificate, you may have a part commencement certificate. You may take time to take the balance approval, but at least you must have a commencement certificate. So without that, you can't register your project. So this will protect the interest of consumer, like fly-by-night operator, where they don't have any plan and they just take the money and go out. And then there is no one to find out. Now, there is a concept of separate accounting. This is not an escrow account. This account should be with scheduled bank and 70-30 is the ratio. Right? Now, there are lots of confusion about this separate account. Many bankers were not issuing checkbook for this separate account. Actually, bank have no role to play. This separate account requirement is by way of a declaration. Under section 4, we have to give one declaration. In that declaration, in form B, we have to specify that we will use this money for the project only. We will withdraw the money in accordance with the law, which says you have to have 3 certificates: architect, engineer, and chartered accountant. So unless I have this certificate, I cannot withdraw the fund. But bankers, still today, many bankers are not issuing checkbook for separate account. As such, bank have no role to play. It's a self-compliance. Because bank themselves have failed to protect their own fund. The NPAs are mounting up. There are Nirav Modi-like situation. So this is a self-compliance. Again, when this 70-30 came, so one builder, while registering his project, came crying to me and said, yeah, this is very unfair. Like many people are doing other works contract, like for example, lift company. That is also works contract. They collect the money 90% in advance. But there is no such requirement for them to have a separate account. Then I said, see, your community is a notorious community, so this provision has came. But still he was not convinced. So I knew that he was a married. And I told him, okay, look, you give me answer after some 2-3 minutes and tell me which system is better, marriage system or RERA system. So after some time he said, no, RERA system is better. At least I am having 30% in my hand. Then now developer is given one chance to revise his timeline for ongoing project. Like previously, suppose he has given 16. Now he can say, I will complete by 2020. But in some of the cases, the project was started in 2011, but they have given the timeline 2040. Now that can be challenged because your timeline should be commensurate with the progress of the work. So you have to give a reasonable timeline, and there are many judgments where timeline has been preponed by the authority. Then there are heavy penalties and prosecutions. Then early formation of association. This is again a new change. Like previously builder used to form the society after the end of the project, but now as soon as the 51% booking is done, you have to start the process of formation of the society. Yeah, this is most important. Previously what used to happen, I used to book with X builder, and when the possession comes, there is no such X builder, now there is a Y builder. Because without my knowledge, there is a change of hand of the project between X and Y. I never wanted to deal with Y. I wanted X only. So this change of hand was done without my consent. So now there is a provision. You cannot change the hand more than 51%. You cannot give the stake more than 51% without the consent of allottee as well as authority. So this is a welcome amendment. Then control on financial movement. As I said, now no developer will be able to purchase the land of project 2 out of the fund of project 1. Yeah, 30% is free. 30% he can use anywhere, but 70% he has to use for project 1. Now there is a fast track dispute resolution system. Yeah, this is also important. Insurance of title of land. So in India, the land is the main defective. There are so many issues with the land, and land is, I suppose, land is not time barred so far as the claim of the land is concerned, dispute of the land is concerned. So it can crop up after 30-40 years also. Like if I have given some money to Naveen Bhai, so after 3 years it's time barred. But it is not the case of land. Land issue can crop up after 30-40 years between legal lands and all these things. So they have provided for insurance of title of land, one-time insurance, but again this cost will go to the buyer only. But they have not yet notified it. It is to be notified by the central government. Then there is a threat of revocation of project. So all this will help the real estate industry to give confidence, will bring the confidence among the consumer as well as financer. So now those in short term, the developers are apprehending that we are at loss, but in the long run certainly they will be at profit, because this will bring consumer confidence as well as financial. Now who are the stakeholders in the real estate industry? ये नहीं आ रहा ऐसा कलर है इसकी वजह से ये जो ये सब नहीं प्रिंट आउट में से हाँ प्रिंट आउट में स्मॉल में Now, who are the stakeholders in a real estate industry? So, unless we understand this, then now what will happen? We will have to plan the structuring of transaction well in advance, because now there are GST issues, income tax issues under various complex situations. So, landowner is the main person who has the land. Then he may give that land to the promoter by virtue of a development agreement. This was common in India till now. The landowner gives his land for development through development agreement, and then there are two modes of sharing, either revenue sharing or area sharing, right? Either top line sharing or bottom line. Revenue can be shared top line also and bottom line also. Net profit sharing is also possible. Then what happens if I am holding a development agreement rights? Then I can also assign this right to another builder. So now there are three persons, landowner A and B. So I have assigned the development right to B. So we all are the promoter, so far as RERA is concerned. So under RERA, all these persons would be promoter. Then cooperative housing society and their members. Then cooperative housing society, because cooperative housing society is the owner of the land. Now legal position is this: though we are staying in the flat, we have only right to occupy and enjoy the flat. The legal ownership of entire land and building rests with the society.
Only under the Hawaii apni.
Member also or only cooperative housing?
There are judgment, unfortunately there are judgment that members are also refuse the relief under RERA. Now that are subject to challenge. Authority have given the judgment that members are the promoter, because promoter is a person who construct or cost to construct. So these are the person who cost to construct. By virtue of resolution and all these members have agreed, but as such member and society are different person in the eye of law.
Judgment is in the context of tenant.
No, even society also they have given. There is one judgment. I will give the this thing. Then SR and other tenant, like in slum rehabilitation also there are tenant. There is a society. In slum rehabilitation, what happens? There is no MIBAP of that land sometimes. So there is a slum. Now the biggest slum of we have in Dharavi. So then they form one society. So that society will get a lease deed from the government. And then there are members of that society. Now again, all these members and society, they are the person who cost to construct. They themselves are not constructing, but they cost to construct. So they are also promoters. So they are also denied the relief. There is a judgment. Again, yes, it is subject to challenge because this is given by the authority. Then there is one now new concept emerging, that is development manager. You might have seen some hoardings saying that project developed and marketed by Godrej, L&T, big name. So here what happens, the title of the land remains with the landowner. So why this is done? Basically, because if I am suppose taking a development agreement, then even I am sharing the risk of title also. Right? Then there are implications of income tax and GST on development agreement. So to avoid all these things, now this new kind of arrangement is being done, that is a development manager, wherein he will have all the authority to do all the act on behalf of landowner. The books of account will be of the landowner. He will be doing everything by virtue of power, a watertight agreement. So here landowner, say in case of area sharing now as per Income Tax Act, landowner will be subject to tax once the OC is received, whether he has sold or not. Right? But here in development manager module, he will be subject to tax as and when he sells. So that portion will be work in progress. So whenever he sells, he will be subject to tax. So there is a better plan in a development manager. He retains the title, land also is retained by the landowner. Ultimately it is conveyed to the society. But this development manager, they share the revenue, gross revenue, by way of percentage. Now currently all these big brands like L&T, Godrej, Tata, they are doing all this development manager, but very soon real estate will be totally carved out, like some category. Some category would be doing only pre-acquisition task, that is pre-acquisition of land, title removal, defect removal, and then second body is that who do the construction, third is the marketing. So now we will have a specialized activity. Now relief. Now you can claim relief under section 12 for any false information. Suppose at the time of booking there are some false information given, then you can claim your money back with interest and compensation. Then under section 13, there is one provision that developer cannot accept more than 10% without executing the agreement and registering the agreement. Now this provision was there under MOFA also, but it was 20%. But no one cared because no one has fear of law. So now it's a punishable. So now one cannot collect more than 10%, there is one question, if the customer agrees voluntarily, I don't want to register the agreement, can he do so? No, because this is a statutory provision. Developer will not be able to collect more than 10% without registering the agreement. Under section 18, there are two options to the allottee. If there is a delay in possession, either he can remain with the project. In that scenario, for delayed portion, he will get the interest. If you want to exit, then he will get interest right from the beginning of when he has made the payment. He will get the money with interest. Now under MOFA, there was only one relief, that is exit. So previously what used to happen, suppose in Thane, I have booked a flat at say 1000 rupees and now the price is 10,000 rupees and there is a delay. So builder never used to bother. He said, you want to exit? I am allowing you to exit. But then that is a loss to the customer. So now under RERA, that is compensated. Now you can remain with the project and claim the interest for the delayed portion. Suppose the project is delayed by 5 years. So then at least 50% of the amount what I have paid, I will get the interest. Per year, say average 10%, I will get 5 years, 50%. And still I enjoy the price rise appreciation. So this is a beneficial. Then there is a 5-year warranty, which was in MOFA, it was 3 years warranty for structural defect, workmanship, quality and all these things. Compensation is also there, like if the interest is insufficient, but builder has taken a major advantage by purchasing land out of my money, then if that can be proved, then you can claim compensation also. So these are the reliefs. Now allotment letter. Now pre-RERA, all the builder used to say, if you have allotment letter, you don't have any right because you don't have agreement. So they quote one Supreme Court judgment, Hansa Gandhi versus Deep Roy. Now in that judgment should not be taken as it is. It should be read properly because that was the case of a conditional intent letter where there were so many conditions laid down and there were so many disputes. So in that case it was held that allotment letter is not agreement. But when the matter, and initially the RERA authority also took up the view that for allotment letter you will not have any relief. You must have agreement. If you want to claim relief under section 18, which specifies that in terms of agreement, if there is a delay, then and then only you will get the money back. So they, in the initial stage, RERA authority also said that you will not get the relief. But then tribunal in JVPD property very broadly cited two law, even cited Supreme Court judgment in Hansa Gandhi also. Yes. Yeah. And there are two judgments, Delhi High Court and Mumbai High Court, which very well says that the terms of allotment letter is what? It is nothing but a contract under Indian Contract Act. And what is agreement? Agreement is matching of two-person mind. If you decide on some parameter like carpet area, sales consideration, date of possession, balance payable on possession, car parking, whatever. If you are agreeing on all these things, then what remains? So allotment letter itself is an agreement. Though it can be said it's an oral agreement or unregistered agreement, but it itself is an agreement. So now it is settled by tribunal in JVPD properties. The allotment letter you can claim interest also and you can claim your money back also. Right? Now leasehold apartment. Now what happened in the matter of Lavasa, Jitendra Tulsiani and versus Lavasa, Ramani appeared before the authority also and tribunal also. So at authority level, there was too much pressure for Lavasa because there is a tremendous delay. The fact of the case are like this, there was 999-year lease. They used to collect lease premium at first stage and then 1 rupee rent every year. So under the definition of allottee, if the arrangement is of rent, then relief is not available, then he is not allottee. Under the definition of allottee, if the arrangement is of legal license, rent, then it is not available. But so taking that, authority denied the relief to the customer. The matter went to the tribunal. Tribunal said no, the order requires interference, and yes, leasehold rights are also covered because in the definition of allottee itself, it says building, flat or apartment in bracket, freehold or leasehold. So they again remanded back the matter to the, yes.
this case, since I had appeared, let me tell you, this was a very important case. If supposing they hold the lease, this case was like this. One Jitendra Tulsani, he had paid about 44 lakhs and entered into agreement on 4th April 2014. Possession date was mentioned as 30 months. And then this was, of course, the delay was there. So Jitendra filed a petition, the complaint that I must get back my money. I don't want to continue the project. Now, in fact, Lavasa Corporation had registered the project with the RERA authority. Here, the entire amount was paid and 1 rupee was chargeable, and the lease period was 999 years plus further option of 999 years. Now, read the definition of allotee. Section 2D says, allotee in relation to a real estate project means the person to whom the apartment, plot or building has, as the case may be, has been allotted, sold, into bracket, whether freehold or leasehold, and then further or otherwise transferred. Means in any manner it is semi-transferred in any other manner. Lease is also a mode of transfer. What is lease? At the end it says, but does not include a person to whom such apartment is given on rent. Now the case of Lavasa Corporation contended before the authority, we are landlord, we are not builder. So we asked them, why did you register the project? Not to be on the safer side. That means you are a doubt. And how can you say when the project is sold for perpetuity, 999 years plus 999 years, and only 1 rupee rent? And not only this, they had taken 44 lakhs, they had also taken 50,000 rupees deposit. Now interest on 50,000 in yearly, it will be much more than 1 rupee. How can, there can't be any default. And secondly, lease is one of the mode of transfer as section 105 the Transfer of Property Act. Lease of property, it is transfer of a right to enjoy the property for a certain period or in perpetuity in consideration for a price paid or promised. There is a price in lease also. Then section 54, I had quoted section 54 of Transfer of Property Act. Sale is a transfer of ownership in exchange for a price paid. Here also price is paid. So we have got income tax judgment of SC CIT versus Panberry Tea Company, where they have defined premium paid for acquiring leasehold right is the price paid for that. So moreover, Supreme Court has held in the case of Saroj Agrawal versus CIT that two technical and legalistic approach should not be made in beneficial legislation. This is the RERA is a beneficial legislation. With any legislation which confers benefits to the subject must be interpreted liberally. This was not interpreted liberally. They said we are landlords, so you have no jurisdiction. So tribunal said no, this is not a rent agreement. This is really a sale in perpetuity. And directly there is a Bombay High Court writ petition in the case of Savani Cooperative Housing Society Limited, where said the word conveyance used in MOFA would include the lease for 999 years. So after considering all this, tribunal said no, this is not a case of rental agreement, but this is a case of proper sale agreement. So this case was sent back. The Lavasa went to the High Court. High Court also strongly said no, they have got no case, go back to the authority. So subsequently, some other cases were also decided by the authority.
So now this is the last slide, possession. Now once no one can enter the apartment unless there is an occupancy certificate or completion certificate. There is a debar on consumer also as well as developer also. No possession can be given without a proper occupation or completion certificate. So there was a specific provision under MOFA. Now many builders used to give fit out possession. Now what is fit out possession is for furniture and all these things. So in one of the case, the fit out possession was given and then customer wanted to have the section 18, that is refund of money. Then developer said, no, he has already taken the possession, so no relief should be granted. But tribunal said, no, fit out possession is not a legal possession. So what is legal possession is, that is after occupation certificate. But in many cases, after fit out possession, people start living in it. Like in Mumbai, we have many such society where we don't have OC since last 30 years, but still we are staying. All these projects will not be an ongoing project under section 3. Right?
So, possession, RERA, builder has to take the permission from the RERA?
No. It's an internal arrangement, but it is not a legal possession.
What is different between OC and completion?
See, it is in some of the area they give occupancy certificate and then completion is, first the occupancy certificate is given and then completion certificate is issued. Yeah.
Completion, you see that the section 2Q has been defined. Project has been developed according to section plan. Supposing there are 2-3 buildings. So there is a clubhouse, there is the office, there is the gym. So it has been developed according to section plan. And whereas OC permits occupation of a flat where there is a provision for water, sanitation and electricity. Only if it is there, that OC can be granted. But there are other layouts, there are other things. See, when the land is more than 1000 meter, as per BMC law, you have to acquire, you have to take layout plan approved. Or if there are more than one building, you must have layout plan approved. So the completion case, normally in single building, OC is enough. But OC, supposing you have in one building also you are showing society, office, gym, this and that. So even if gym and society, office is not complete, OC can be given. But completion can be given only after completion of gym and society, office, etc. That is the difference.
So there is one interesting judgment from National Consumer Forum, wherein one society in Andheri, Mumbai, they did not have OC and conveyance for last 20 years. So the society filed a case with National Consumer Forum asking for relief. So then this is a landmark judgment where the relief was granted in terms that developer was told to refund the municipal tax and water tax to the society because there is no OC and conveyance. So for this 20 years, this is a judgment. And now as regards the covered parking, there are confusion whether still in RERA, because under MOFA, you were not allowed to sell even the covered parking. There is a Supreme Court judgment in Nahalchand, Laluchand, wherein you cannot sell even the covered parking. But RERA defines the covered parking and now under the agreement also you can sell the covered parking. Now whether that Supreme Court judgment will hold good to RERA also, because it was in the context of MOFA. It applies only to Maharashtra, whereas RERA applies to entire country. So whether this Supreme Court judgment will still hold good or not? Your views, sir?
No. Now, if you see the agreement here clearly, they have defined what is garage in the RERA, and they have also defined covered car parking in the rules. They clearly say only open car parking cannot be sold by the builder. Under the MOFA, there was position was, and here in the model agreement, if you see, this is a consideration for the flat is so much, consideration for covered car parking is so much, the aggregate consideration is so much. So there is a consideration for covered car parking. So under MOFA, as per Nahalchand Laluchand's case, only flat could be sold and nothing other than the flat could be sold. Here, apart from flat, covered car parking and garage can be sold. And not only that, in garage, under RERA, garage can be sold to the non-member also. This is my view. But covered car parking can be sold only.
But then for ongoing project, if there is a MOFA agreement which are entered in MOFA regime, but now we are under RERA regime.
Under RERA regime, these are the concessions being given in RERA.
So if the agreement is under MOFA, that cannot
Then
be.
I think maybe this Nahalchand Laluchand's case.
Correct. So now what is future ahead for real estate sector? So again, the promoter, the developer says that they have the ability, they have the experience, they have the risk appetite, but they lack credit. So credit is the main backbone of any real estate project. But now with RERA, credit lines are improving, and even bankers also will have a confidence. But the main problem is the approval authority. There is no system of single window approval. Again, the law changes. So the developer, even the viable projects are getting turned into unviable, non-loss-making projects. Again, the purchasing power of the people will also decide. Nowadays, we all people feel very hard even to buy a flat of 2 crore rupees. It is very difficult because all are hit by demonetization, GST, RERA. So purchasing power is also defeated. Again, government policy. Government says we want house for everyone by 2022. But with these steps, it is not possible. They have to give some concession like GST, concession in GST, stamp duty and all these things. Otherwise, it is not possible. So all depends on the government policies, whether they want, what they want to do with the real estate sector. So that's all for today. We had little short of time. Thank you everyone.
Thank you so much, sir. At this juncture, I would request Pranav Kapadia to present a memento to our chairman of this session, Shri K K Ramani. I would request Shri Girish Rathi to present a memento to our speaker, CA Ashwin Shah. Thank you so much. And now I hand over the floor to Chairman of this National Tax Conference, Shri Adv K K Ramani.
Good evening, everybody. Good evening. Friends, I am sure you all must have enjoyed the 2 days and all the technical sessions, and definitely you must be going enriched with by the sharing of the knowledge by our esteemed galaxy of speakers. I have here to just thank you all for having come here from across the country and making this conference a success. I would like to start with thanking. First, initially, I would like to thank the speakers and the chairman, Shri K K Ramani ji, who normally doesn't go because of his health. But at my personal request, he has accepted and he has come here as the chairman, and I am sure we must have benefited from his experience. And Ashwin, also, he's tried to cover the topic as well as possible, but because of shortage of time, sorry Ashwin, we could not grant you because of shortage of time.
Next time.
Sir, just one word, he is the hero of RERA.
Because when we suggested the name of Ashwin, it was just thought कि भाई नया आदमी है कैसा होगा, but he has proved that he has good knowledge of RERA, and I think you will all agree that he has done justice to the topic in spite of having such a short time. Now coming back to the vote of thanks, I would like to thank our National President Shri Ganesh Purohit ji, our National Executive Committee for having given me the opportunity to conduct this conference at Thane. And then definitely I would like to thank our joining association GSTPM, led by Shri Adv Kapadia ji, for having agreed. And definitely my team at TPA, Thane and Tax Friends, without their support, I would not have been possible to do it. Before ending, I would just like to recognize the services of our MOC Srimati Ashwin Shah by giving her a memento. I would request the National President to kindly hand, Ganesh Purohit ji please, to hand over a memento to her. आइए ना ऊपर आइए ऊपर. Friends, she has come all the way from Baroda just for being an MOC over here. And for 2 days, I am sure you will all appreciate the way she has conducted the session. Thank you, ma'am. Thank you for coming. I would also like to thank all our sponsors and advertisers who have contributed I would be failing if I fail to thank the contribution of our guide, mentor, and the guiding force, Shri J.D. Nankani ji, who has always inspired me. Vijay, be positive, we will have a positive result. And also I would like to thank Dr. Murthy, whom when I just called up, sir, we may have some financial difficulties. He said, Vijay, you don't worry, I am with you, and he supported us financially so that we were able to cover our deficit. And last but not the least, all you delegates whom you have come from across the country, just as a single word on my phone call and making it a success with over 325 registrations here. I would also like to thank the management of Satkar Residency for giving us all the facilities. I am sure you must have enjoyed the facilities and the room service and the rooms. Thank you, friends. Looking forward to meet you at there. Thank you very much.
Let us give a standing ovation.
Yes.
Thank you all. Vijay means Vijay. Vijay means Vijay. Vijay means Vijay.